I want to start by apologizing to the city attorney's office. This happened to come up on tonight's agenda. I know how hard your department has been working on an issue we have later on the agenda, and there are people here to speak to about the airport. So it may be a little bit cruel to be handing you a long list of to-dos at this point. But having heard what we've heard from the community, having my own personal experience of picking up the phone and hearing from tenants in distress, and knowing that with the passage of Measure RR, we as a city both extended protections to a greater number of renters and to some extent took on responsibility for making sure that those protections were actually afforded. I'm going to go forward with a list of things I've heard tonight that I'd like to put on that to-do list, with the understanding, of course, that we can't pass anything tonight or fund anything tonight. What we can do is ask you to evaluate a number of problems that have been articulated, options that have been suggested, and to come back to us with priorities, recommendations, costs, legal limits on what we can do, etc. So let me go through this, and I'll since we've already talked about them, I'll try not to get into too much detail. One thing that's been discussed I thought was very interesting was when we wrote the tenant harassment law, and I was part of the council that did that, we used the word malice, which I think was the intent to annoy, harass, or vex, or something like that. And maybe that's a difficult term, and I believe that bad faith is defined in a number of places in existing law. And that would be something you would have to tell me as a non-attorney. Would the adoption of a definition of bad faith make it easier for your office to pursue some of these cases than having to prove the level of malice, which we defined? I've also heard some concern about non-coordination among city staff itself, where, for instance, our building and safety people issue a permit for a certain kind of work, not realizing that there's no means and method plan in place to protect the tenant from being harassed by having the work take 15 months instead of 15 days. So I'd be interested in what kind of interdepartmental communication might assist with some of the situations that we've heard about, particularly having to do with means and methods plans and whether or not we have enough of a handle of when the discomfort of living with construction should really result in temporary relocation for that tenant, because otherwise it's used as a means of harassment for the tenant. You know, homeowners complain all the time about, we got a contractor and took them 15 months to finish the work, but when that happens to you and you're a renter, you have no recourse at all. And you're living with a wall that's been torn open for plumbing or whatever that stays that way for months. So that's something I'd like to follow up on. The very difficult to pronounce word ombudsperson comes up in this, and I have to wonder, given that you're constrained in fairness as attorneys to contact the landlord and get the other side of the story the moment you receive a complaint, is there indeed some intermediary position we could create where the tenant in distress could get some support and advice? Then that advice might include talk to a lawyer before it gets to the point where you pick up the phone, call the landlord, and the landlord now knows she or he has a complaining tenant, and perhaps steps up the harassment. If that would take augmented resources, I'd be interested in knowing what those resources would be, what would be needed, and when. And again, I think that A, under the passage of Measure RR, we've taken on more responsibility than we had before. And B, as Ms. Phyllis said, I think quite articulately, there's a community loss every time a tenant loses, is harassed, or is evicted out of an apartment. So I think there's a reason why the community should have a stake in this, not just the individual. I want to find out more about the inspection issue, and if we can define what is allowable and not allowable and explain that to tenants. I understand one of the things that's done is that sometimes a landlord will go in, do an inspection, and deliberately be provocative in the way that she or he does it to get the tenant to react in a way that then justifies some other charge that results in eviction. And I'd like to know how we can keep that from happening. There are a number of points that are made in the letter from the Legal Aid Foundation of Los Angeles that we didn't get to, so I'll incorporate in my comments by reference that letter and hope that we can get responses to things that might not have been mentioned tonight. One thing that Legal Aid talked about was relocation agreements or disagreements. And is it possible, for instance, for us to require that if a landlord presents a tenant with a relocation agreement, that in Santa Monica, there must be a statement there of what options you would have if you stayed and how you might end up being eligible for Section 8 or something else, so that the tenant knows the full range of the deal that's being offered to them and what they're giving up as well as what they might be getting. Obviously, it's a free speech right of the landlord to make the offer, but we have other places where we require that offers are backed up with information. I'd like to see what we could do. You've talked a bit about rental payment assurance. I think that the escrow account is interesting, but might be difficult because state law does say it's up to the landlord how to accept the rent. We heard tonight, and I'm very proud of the fact that Santa Monicans for Renters' Rights has had a tenant hotline for many, many years, and that number is available to people, 394-0848. But might not the city have a tenant abuse hotline? Somebody mentioned the fact that under certain circumstances, if what was happening to a tenant was happening to a senior citizen, that they'd immediately pick up the phone and call the senior abuse hotline. Is there anything like that for tenants, and should there be in Santa Monica? Attorneys, if a tenant goes to court on an unlawful detainer without an attorney, that is a tenant who's going to be moving soon, which is not the outcome we necessarily want. If they income qualify, we have just funded an additional attorney for LAFLA, and that will be helpful, I hope. But of course, there are many tenants in apartments in Santa Monica who may not be paying market rate rent and therefore are subject to harassment and possible eviction, who are not income qualified for LAFLA. Is there anything we can do to build up a list of pro bono, or even perhaps if we take to heart what Ms. Phyllis said about the community benefits of our laws, a subsidized attorney, so that we make sure that no Santa Monica tenant ever goes to court unrepresented if they can't afford to hire somebody? And then lastly, there was a question about how we might follow up. Once someone has successfully defended themselves against an unlawful detainer, the prize is they get to go back to where they were before they started, and they're poorer, and they're probably stressed out from it, and they're probably susceptible to going through the whole cycle again. Is there any possibility for a follow-up suit against the landlord, kind of like a slap suit in other things, and would that be something that we might do to gain money to put into a city fund to make it a self-perpetuating, self-funding process? So I think that's enough to give you for one night study session, and I thank you. And I thank the members of the public who came and testified. This is a crucial issue to our city, and I'm really glad to be pulling people together to find solutions.